Righty. It looks like our numbers of people joining the numbers are leveling off a little bit here. It's 2 minutes after the hour. Hello, I'm Marcus Christian, and welcome to our U.S. Cybersecurity and Privacy Regulatory and Legal Roundup. We want to thank you for joining us as we kick off Mayor Brown's observance and participation in National Cybersecurity Awareness Month. Today, we're going to put a spotlight on the shifting legal and regulatory cybersecurity and privacy landscape. But before we begin in earnest, I want to take a moment to put in a quick plug for Mayor Brown's exciting lineup of presentations throughout the month addressing priority cybersecurity issues facing businesses. Now, some of you may be thinking, how can it be exciting when lawyers are going to be talking about computers and privacy issues? I assure you that it'll be as exciting as it can be when lawyers are doing it. I'm fortunate enough to be a member of a group with colleagues, esteemed cybersecurity and privacy members who are quite knowledgeable, and we'll talk to you this month about a range of cybersecurity developments in Europe and China to managing cyber risks with industrial systems. We'll also be hosting a cyber perspective series featuring fireside chats with representatives from major companies from a wide range of industries. We sincerely hope that you will join us throughout the month as you are able, and you, by joining us, will be able to say for yourselves that this was an exciting these were exciting events. So without further ado, I want to tell you about something that some of you may be interested in, and that's if you are viewing this webinar live and applying for CLE credit for this program, we'll be providing a code during this presentation, which you will need to include on your CLE form. If you're watching a recording of this webinar, however, CLE credit is not available. Again, my name is Marcus Christian. I'm a partner in Mayor Brown's cybersecurity and data privacy practice. I'm also a white collar and defense attorney. I'm a former federal prosecutor. I also serve as the co-leader of DC's litigation and dispute resolution practice. Before joining Mayor Brown, I spent better part of a decade as a federal prosecutor, and that's where I had my first investigation dealing with cyber actors, as well as a number of issues resulting from threat actor activity. So I'm pleased to be here with you today, and I'm very pleased to be here with my colleague Vivek Mohan. Vivek, tell us about yourself. Introduce yourself, please.
Thanks, Marcus, and thanks everybody for joining this morning or this afternoon, depending on where you are. My name is Vivek Mohan. I'm a partner in Mayor Brown's Palo Alto office, also a member of the cybersecurity and privacy practice. My practice, like Marcus's, is across industry sectors on legal, regulatory, compliance, and policy issues. I focus exclusively on privacy and security. I help clients with counseling, transactions, and advocacy. And I joined Mayor Brown just earlier this year from Apple, where I was a senior attorney on the privacy law and policy team. So looking forward to speaking to you today. I'm sorry about those technical difficulties. My slide deck got a little too excited. So we probably need 5 or 6 hours to cover the full range of developments that have taken place over the last year, but we're going to squeeze it in as best we can in the next 40 minutes or so. We're going to focus pretty heavily on regulatory and executive branch developments over the last year, as we've seen a really increased focus, particularly in the Biden administration, on pushing out more comprehensive cybersecurity rules and guidance. We'll touch on state and federal legislation and a little bit on key litigation developments towards the end. If we have time at the end of the webinar, we'll take additional questions, but please feel free to ask questions in the chat throughout the presentation. We'll make some efforts to pause and answer them before we move to between section to section. So please do keep them coming in. We'd be happy to make sure we address them. To the extent that we don't get to them during this call, we will get them and follow up with you afterwards. So let's dive right in.
All righty, next slide, please. And one more. All righty, so as you know, the FTC has been a major figure in the federal landscape of cybersecurity and privacy regulation for a long time. You might even recall the quote of an FTC commissioner saying that the FTC was the top cop on the privacy beat, and they certainly figure to be active this year and next year and into the future. The FTC's current chair, Ms. Lena Khan, has been a leading critic of big tech's market power, dating back to her 2017 Yale Law Journal note focusing on the dominance of a very large, one of the largest technology companies. Chair Khan's priorities include the FTC pursuing a holistic approach to competition and consumer protection by breaking down silos to focus on the greatest consumer harms. Now, recently, the FTC announced a series of reforms to the data security orders that it puts into place when it settles cases. First of all, the orders will be going forward more specific, and they're going to require companies to implement specific safeguards to address the problems that are alleged in the complaint. Secondly, the orders are going to increase third-party assessor accountability. Now, you may know that FTC relies on outside assessors to review the comprehensive data security program required by its orders. And now they're going to require even more rigor in these assessments. And thirdly, the orders elevate data security considerations to the C-suite and the board level. For example, every year companies must now present to their board or similar governing body their written information security program. That's a word that we started hearing around 2010 when the state of Massachusetts instituted a requirement, and it's something that hasn't gone away, and it's going to become more and more widespread. I'm going to turn over to Vivek.
Thanks, Marcus. And the FTC has been really active, as folks likely know, for quite a while on privacy and security. One of the things that is a pretty key recent development that we'll talk about later on in our presentation is a letter that was written earlier, I guess last month, by a number of Democratic senators to the FTC, encouraging rulemaking under the Magnuson-Moss rulemaking procedures to protect consumer privacy and set clear safeguards on collection of use of personal data. The senators had a number of stated goals, but I think what's particularly interesting here is that these are rulemaking procedures that are likely to take some time should they be undertaken, and we're likely to see this as a bit of a long pull and not something that really changes the landscape tomorrow. The FTC submitted a report this year to Congress on privacy and security, and they highlighted 4 areas in which they have been improving effectiveness on privacy. First was integrating competition concerns, and for those of you that practice or appear before the FTC, you know that they have 3 key bureaus: the Bureau of Consumer Protection, Bureau of Competition, and the Bureau of Economics. And so the Bureau of Consumer Protection, which has traditionally led on privacy issues, it's clear that they are going to look more to the overlap between competition and consumer protection concerns. And the FTC has a particular advantage here, given that it has this dual mandate. The FTC is also looking to advance remedies. It's looking to provide notice to harmed consumers, obtain monetary remedies for harmed consumers, non-monetary relief for consumers, and allowing companies or stopping companies from benefiting from data that is collected in violation of Section 5. The FTC plans to expand its focus on digital platforms, particularly major players, and they've issued already a number of orders against major tech companies with penalties that range in the $40,000 range per violation. And this really adds up when you talk about that on a per user basis. The Commission has explicitly stated that it'll shift resources from compliance to order compliance and enforcement to ensure that the orders that they approve have maximum credibility, disincentivize violative conduct, and improve practices across the market over time. And the FTC is also focused on expanding guidance. And this is, I think, something that's particularly important and will continue to track very closely. And we've already seen guidance this year, for example, on the topic of use of algorithms and AI, with a focus on truthful, fair, and equitable use of these technologies. One of the things that has come to the attention of a number of legislators, and has been discussed in public quite a bit, is that the staff of the FTC Division of Privacy and Identity Protection is approximately 40 to 45 employees, whereas the Data Protection Authority of the United Kingdom, the Information Commissioner's Office, has roughly 750 employees, and the Irish Data Protection Commissioner's Office has about 150 employees. And this is seen as an area where the FTC may really need to staff up, and that Congress may need to provide them resources in order to discharge their mandate. I'm sorry, my mouse is very, very happy to move forward from slide to slide. There have been a number of really important rulings and enforcement decisions relating to the FTC. Probably first and foremost is the ruling in AMG Capital Management versus FTC in April of 2021, where the unanimous Supreme Court ruled that the FTC lacked the authority to seek equitable monetary relief, such as disgorgement or restitution. And this means that the FTC must first look to administrative procedures and can't look to such relief directly through a lawsuit in federal court. With that in mind, the FTC has still managed to finalize a number of enforcement actions on privacy and security, including against SpyPhone, which was a stalkerware app, QHub, which collected information about children, arguably without their consent, and notifying their parents. Flow Health, which was or is a popular app that provides fertility tracking, but shared information with outside data analytics providers after promising such information would be kept private. MoviePass, which failed to secure subscribers' personal data. And EverAlbum, which was alleged to have deceived consumers about its use of facial recognition technology and how it retained photos and videos of users that deleted their accounts. I think that each of these and many of the other recent enforcement actions by the FTC provide a really interesting roadmap into how the Commission thinks about its authorities, as well as areas that companies need to make sure that they're particularly cognizant of when making decisions that have similar facts. As I discussed earlier, the senators, a number of Democratic senators have written to the FTC looking to kick off rulemaking under the Magnuson-Moss procedures. While it's not covered thoroughly on this slide, one of the things that is interesting, and I think that has really been a trend at the FTC over the last several months, is that they are renewing and invoking authorities that have lain a little bit dormant. One of the things that is notable is under COPPA, the Children's Online Privacy Protection Act. There are a number of entities that are listed as safe harbor providers for helping companies handle children's data and secure parental consent. For the first time, the FTC delisted a safe harbor provider earlier this year. And this was seen as a really notable, the FTC is, so to speak, kind of awake at the tiller and paying attention to these issues. Another recent development is the FTC's renewal of a policy statement guidance relating to their health data breach notification rule, which has lain dormant for most of a decade and covers entities that are not covered by HIPAA. And in issuing this guidance and taking these actions, the FTC has really shown that they are focused not only on seeking expansion of authorities and driving forward rulemaking, but using the authorities they already have on the books to the extent possible. So I think companies that have not focused on these issues to date will increasingly look to the FTC as an aggressive cop on the beat. I skipped right over this slide where we did actually cover some of this in more detail, but of course these slides will be provided after the call. Moving forward to another federal regulator that has been taking a number of very aggressive actions on privacy and cybersecurity in particular. We are looking towards a potential for a disclosure rule from the Securities and Exchange Commission. I know that there are already some questions in the Q&A about the SEC's potential disclosure rules, and we are expecting something this October. We don't have a lot of clarity as to exactly what will be in that proposal, but we believe that they will be enhanced scrutiny about what constitutes materiality and timeliness in notices of cyber attack, as well as further explication around what criteria and how companies should issue and provide risk factors relating to cyber risks. Companies can look to the 2018 guidance from the SEC as an instructive starting point for understanding what the SEC's proposed rule may include, but it's not likely to stop there. It's likely that the Commission, in consulting with stakeholders as part of the rulemaking process, will seek to address and bolster perceived deficiencies in the 2018 guidance, including by providing, as mentioned earlier, more instruction on materiality and timeliness. Despite the fact that the proposed rules may not be available till later this month, prudent corporate governance as well as shareholder awareness will lead companies that are thinking critically about this issue to proactively revisit and enhance cybersecurity disclosure policies, internal controls, and procedures to be ready for inevitable cyber events, as well as the likely inevitable rulemaking procedures. The SEC, I think, is interest in this area can be particularly seen in the now public probe and investigation they have launched into the SolarWinds incident. As some or many of you may recall, towards the end of last calendar year, it became clear that there was a major cybersecurity incident impacting a number of companies, as well as many agencies in the federal government through a compromise of a company known as SolarWinds. The SEC has launched an investigation and sent out a sweep letter to a number of public issuers requesting information about their exposure to the SolarWinds incident, as well as information about, quote, other compromises that that such entities may have suffered. While it's styled as a voluntary request, the public nature of this sweep and the enforcement discretion that has been offered to companies that cooperate with the SolarWinds aspect of their inquiry really leads to a clear picture that the SEC is thinking critically about these issues and is focusing its enforcement authorities, not just its traditional oversight bodies for regulated entities, such as their Office of Compliance, Inspection, and Examination, on how cybersecurity, internal controls, and disclosure controls may relate to their traditional remit and their traditional oversight. We've seen this come to fruition. There have been a number of cases over the past year that have started to really reshape the landscape. Until recently, the SEC's disclosure controls were limited to cases that involve failure to disclose known breaches, as well as some enforcement actions against regulated entities for violations of the safeguard rule. A string of cyber enforcement actions signal, again, that this is a top priority for the Commission. In August, the SEC sanctioned 8 firms in 3 separate actions for failures in their cybersecurity policies and procedures that led to compromises. The chief of the SEC Cyber Enforcement Cyber Unit mentioned that investment advisors and broker-dealers must fulfill their obligations concerning the protection of consumer information. It is not enough to write a policy that requires enhanced security measures if those requirements are not implemented or only partially implemented, especially in the face of known attacks. And these led to significant monetary penalties for these firms, and more importantly, reputational consequences, as oftentimes cybersecurity incidents can lead not only to regulatory outcomes, but also reputational impacts that can directly impact your business. On the public issuer front, the SEC sanctioned Pearson, a London-based educational publishing and services company, to the tune of $1 million to settle charges that had misled investors about a 2018 data breach involving millions of student records, as well as inadequate disclosure controls and procedures. This follows in a line of cases that have started to come together and really demonstrate that the SEC is focusing on this issue, and we can expect this to only continue and intensify as the Commission begins to expand and understand how existing authorities can map into the cyber domain. Marcus, over to you.
Thank you, Vivek. So HIPAA's about 20 years old, or is approaching its 20th birthday. And as we all know, that since early 2020, the response to COVID-19 has taken up a lot of HHS's attention. But one thing is clear, and that is cybersecurity continues to be a priority. One of the reasons you can see this is through the HIPAA Safe Harbor Act, which was signed into law in January of 2021. What it does is it amends the HITECH Act to incentivize cybersecurity best practices based on the NIST framework. HIPAA enforcement actions, as you may have seen over the years, have included some fairly stiff penalties against organizations that experience cyber attacks. And so the safe harbor laws allows HHS to consider what victim organizations are doing to prevent cyber attacks as they determine penalties. And this actually could result in lower penalties. Another notable development is that HIPAA rulemaking is currently in progress proposing changes to the privacy rules that include strengthening individuals' rights to access their own health information, improving information sharing for care coordination and for case management for individuals, facilitating greater family and caregiver involvement, enhancing flexibilities for disclosures in emergency or threatening circumstances, and reducing administrative burdens on HIPAA-covered healthcare providers and health plans. Next slide, please. Okay, so HHS OCR Enforcement in 2021 has seen quite a number of right to access settlements, as well as some security breach related settlements. OCR's right of access initiative is intended to support individuals' right to have timely access to their health records at a reasonable cost under the HIPAA privacy rule. One of the largest cybersecurity settlements of the year basically came in the first month of the year, and it didn't relate to something that happened last year, an incident that happened last year or even the year before. This dated back to a breach that occurred in 2015, and it was a health plan in New York State, and basically it was a breach that affected more than 9.3 million individuals, and the ultimate settlement with OCR for HIPAA violations was $5.1 million. One of the things that you see as you look at HHS OCR is that they take as much time as they need in their investigations, and that oftentimes the large penalties we see are many times looking back several years to an incident. Next slide, please. So as many of you have seen, state attorney generals, they're working together, and you know, the Equifax breach was a good example of that. And since the Equifax breach, we've seen increasing number of state attorney generals collaborating on data breach investigations and cases. Some recent multi-state settlements include: 1, a major big box retailer; 2, a major rideshare company; and 3, a major home renovation supply store. Next slide, please. So we're going to talk a little bit about executive branch initiatives and developments. Next slide. You know, ransomware has been around for a while. The first congressional testimony that I've seen dealing with the idea of taking someone's data and holding it ransom dates back to the 1970s. And by some accounts, the earliest ransomware attack, which was allegedly which took place by sending floppy disks around, occurred in the 1980s. But ransomware in the past year, particularly this year, has been commanding headlines. Next slide, please. Now, this is a busy slide, and for some people, looking at a slide like this may raise their blood pressure and heart rate. But the real point here is just to give a visual representation of how busy the Biden administration has been, or the administration has been, since the SolarWinds incident in 2020. We're not going to walk through this timeline, but we do want to point out a few things. 1, the executive order improving the nation's cybersecurity in May. 2, the confirmation of the nation's first National Cybersecurity Director in June, and the Cybersecurity Summit hosted by the White House in August. Next slide, please. In June, Deputy Attorney General Lisa Monaco issued guidance for all federal prosecutors on investigations and cases related to ransomware and digital extortion. This guidance included the creation of a new reporting requirement, or new reporting requirements for U.S. attorneys' offices during the opening of or significant developments in cases involving ransomware, digital extortion, or unlawful operation of infrastructure used in these types of schemes. Next slide, please. In July, the Department of Homeland Security and the Department of Justice and other federal partners launched stopransomware.gov as a one-stop resource on ransomware for public and private organizations. This website consolidates existing ransomware information from across federal agencies, and it includes guidance on how to report attacks, as well as latest threat alerts. Next slide, please. In August, CISA launched the Joint Cyber Defense Collaboration to lead cyber defense plans with public and private sector entities. The JCDC includes representatives from across the federal government: DOD, DOJ, NSA, US Cybercom, FBI, ODNI, and others. And it's tasked with: one, designing and implementing a whole of nation cyber defense plan, sharing insights to shape joint understanding of challenges and opportunities for cyber defense, implementing coordinated defense cyber operations to prevent and reduce impacts of cyber intrusions, and supporting joint exercises to improve cyber defense operations. Industry partners include many very common names, well-known names: Amazon Web Services, AT&T, CrowdStrike, FireEye, Google Cloud, Lumen, Microsoft, Mandiant, Palo Alto Networks, and Verizon. Next slide, please. Now, after the Colonial Pipeline ransomware attack in May, DHS rolled out cybersecurity requirements for critical pipeline owners and operators, consisting of 2 security directives. The first directive requires reporting confirmed and potential cybersecurity incidents to CISA, designating a cybersecurity coordinator, reviewing current practices, identifying any gaps, and reporting results to TSA and CISA within 30 days. Security Directive 2, which is issued in July, requires implementation of specific mitigation measures to protect against ransomware attacks and other known threats, the development and implementation of a cybersecurity contingency and recovery plan, and conducting and cybersecurity architecture design review. I just want to make one point in the wake of the Colonial Pipeline incident, is that you may all recall that the CEO went to Congress, and one of the things he said was that he'd do the same thing in terms of paying the ransom if he did it again. One theme you're going to see through what Vivek and myself are saying today, and you're going to see it pan out in laws, is that regulators at the federal and state level aren't really receiving very well, and they're going to receive it less well, the idea that in the future you'll do the same thing all over again. One of the themes you'll see here is that they're expecting improvements, they're expecting mitigations, they're expecting growth, and becoming more resilient and more robust in cybersecurity. Next slide, please. In October of 2020, the Treasury Department OFAC issued important guidance on what victims of ransomware attacks should consider when confronted with potential ransomware demands. And last month, OFAC issued updated advisory on potential sanctions. And it basically is talking about sanctions risk associated with making or facilitating ransomware payment, and addresses enforcement considerations. The guidance also reiterates the legal prohibitions on U.S. persons with respect to dealings with sanctioned entities or individuals. Next slide, please. In the updated guidance issued last month, the agency made it clear that it would consider certain mitigating factors when determining whether sanctions are warranted. For example, it's going to consider whether there's an appropriate. Well, excuse me. One of the things it's going to consider when deciding whether to enforce sanctions is whether companies that are victims of ransomware attacks have engaged in appropriate levels of mitigations. Have they hardened their cybersecurity? Have they implemented NIST requirements? And have they engaged with law enforcement? It's going to consider not just whether you engage with law enforcement, but also whether there's been cooperation. And such programs could make a significant difference for companies, even though OFAC can impose OFAC sanctions are strict. It's a strict, basically it's strict liability. Further, companies involved in facilitating ransomware payments on behalf of victims should also consider whether they have regulatory obligations under Financial Crimes Enforcement Network regulation. Put specifically, OFAC will consider meaningful steps taken by victims to adopt or improve cybersecurity, a significant mitigating factor in any OFAC enforcement response to a potential sanctions violations. Companies can look to cybersecurity practices highlighted in the CISA September 2020 ransomware guide for further guidance. OFAC will also consider whether an entity has cooperated with law enforcement, reporting ransomware attack to appropriate government agencies, and its ongoing cooperation with law enforcement during and after ransomware attack. One example is providing all relevant information such as technical details, ransomware payment demand, and ransom payment instructions as soon as possible will be considered significant mitigating factors in determining OFAC's enforcement response. Finally, and this is important, people are always, you want to have specific, straightforward, clear guidance on what you can do to minimize or mitigate sanctions exposure. OFAC has explicitly stated that it is more likely to resolve apparent sanctions violations involving ransomware attacks with a non-public response, and that means no action letter or cautionary letter, when the affected party took the mitigating steps that OFAC laid out. Vivek?
Thanks, Marcus. And just before we move on to our next topic on a quick overview of the White House cybersecurity initiatives, I just wanted to note that, for those of you that are not signed up for our legal updates and client alerts, there's a terrific one that we issued that really provides even more color than Marcus just did on this recent OFAC guidance. So to the extent you're interested, we put out some of our best work product there. So please do sign up, and we'll be happy to help you if you need any assistance with that. So jumping now to White House cybersecurity initiatives, as Marcus noted earlier, White House has been quite active this year in cybersecurity efforts, due in part to the major ransomware attacks, as well as the SolarWinds incident, with the significant impact that we've seen on major corporations and critical infrastructure. The highest profile, I think, decision or action they've taken is issuing an executive order in May, on improving the nation's cybersecurity. Primarily, as given that it's not legislation, it calls for the modernization and implementation of cybersecurity standards across the federal government for IT. It looks to move to agencies towards secure cloud services and a zero trust architecture. Mandates multi-factor authentication and encryption, which are, of course, great and key controls. And it directs the Commerce Department to identify and develop new standards, tools, and best practices for secure software development. I think this is something that we are going to want to watch closely, as it may be one of the elements of the executive order that may have the largest impact on the private sector. It also calls on the Homeland Security Secretary to form a cybersecurity safety review board to convene after cyber incidents to analyze, conduct postmortems, and offer concrete recommendations on how to respond to them. It also calls for a deployment of government-wide endpoint detection and response to help improve insider threat detection and response. And of course, the private sector can learn from some of these developments and how they're deployed by seeing how the government's, so to speak, best efforts look in practice. For companies, over the course of, and this is, sorry, just a little bit more on the executive order. One of the things that's notable here on this slide is that standardized IR playbooks that the government will be putting together as a result of this executive order may be a valuable reference point. We'll certainly be looking to them as we advise clients on how to update and modernize their incident response playbooks in the context of the dynamic threat landscape that we're all facing. Jumping to companies, the White House has also issued a number of memoranda and letters to companies regarding the protection of threats against ransomware, as well as improving cybersecurity for critical infrastructure. In June, business leaders were encouraged to implement the May executive order's best practices to back up data, patch systems, test IR plans, conduct pen tests, and use network segmentation. In a follow-up memorandum, the White House called for the development of critical infrastructure cybersecurity performance goals for owners and operators of critical infrastructure, and also the establishment of an ICS cybersecurity initiative. This would be a voluntary effort between the federal government and critical infrastructure community to support owners and operators of critical infrastructure with the resources needed to detect and mitigate threats. Marcus, over to you.
Thank you. Released for public comment in September, draft guidance documents are meant to provide government agencies with the roadmap and resources required to sustain a multi-year push to zero trust. Now, zero trust essentially is an effort to make it so that within organization, cybersecurity has oftentimes looked at the perimeter, the physical, keeping people outside of the organization and the systems. Zero trust essentially allows for protecting, for basically micro security, protecting specific digital assets such that only those people who need access get access. Now, this effort at pushing forward zero trust is an outgrowth of the Cybersecurity Executive Order signed by President Biden earlier this year. It includes OMB federal strategy for moving forward the U.S. government towards a zero trust architecture and the zero trust maturity model and cloud security technical reference architecture from CISA. Next slide, please. In August, President Biden met with the private sector and educational leaders to discuss the national effort needed to address cybersecurity threats. The purpose of this meeting was to discuss opportunities to bolster the nation's cybersecurity in partnership with public and private sector entities. NIST has been directed to develop a new framework for security of the technology supply chain, and this new framework is being developed as a guideline for both public and private organizations to assess their security posture. Big name companies in the technological space such as IBM, Google, Microsoft, and Travelers Insurance have pledged to participate. The Industrial Control System Cybersecurity Initiative, already in place for the country's electric utilities, is also being expanded to include natural gas pipelines. This initiative sets a new security and reporting standards for the industry it covers, and the administration had previously announced a 5-year plan, gradually to expand it to a wide range of industries that potentially impact national security. The administration also announced that it plans to cover the water and wastewater and chemical sectors by the end of 2021. A number of private entities have committed to rolling out free software, including training and dedicating increased funds towards cybersecurity. Vivek?
Thanks, Marcus. Now for the part that you've all been waiting for, and it's not the legislative developments, but rather the CLE. If you're applying for CLE for this webinar, please include the code on your attorney affirmation form. The code is 10 Roundup. 10 Roundup. ROUNDUP. So with that in mind, over the next few slides, we're going to review cybersecurity and privacy legislative developments, both at the state and the federal level. And as you can probably see, the sun has broken through the clouds in Palo Alto, and I am now really in the featured spotlight. We'll start with state legislation. I think that at the state level, we have seen some of the most interesting developments that have really come to fruition. And then we'll touch and turn on federal legislation that is under consideration. As that federal privacy legislation really stalls out and is replaced by letters to the FTC, more and more state legislatures are focusing on comprehensive approaches to privacy regulation. We've seen at least 38 states introducing over 160 consumer privacy related bills in 2021. And focusing on issues such as genetic information, facial recognition tools, biometrics, as well as a number of comprehensive consumer data privacy bills. 3 states this year, over the past 12 months, enacted comprehensive privacy laws. California, the California Privacy Rights Act, which replaced the in effect since 2020 California Consumer Privacy Act. Colorado, which enacted the Colorado Privacy Act, and Virginia, which enacted the Virginia Consumer Data Protection Act. We are in for a real alphabet soup. A key stumbling block in the states where comprehensive consumer privacy efforts failed was the private right of action, or the enforcement mechanism. Industry groups have taken a strong stance against the private right of action, while the plaintiffs' bar and others have sought to use it as a way to ensure strong enforcement of the provisions of these privacy laws. One trend that we are seeing is that there is bipartisan support for the majority of the provisions that are discussed in comprehensive privacy legislation, We've seen that in the movement of bills that have worked their way through Florida's more conservative legislature, as well as Washington's more liberal legislature. While neither of these made it to the finish line, we will continue to be monitoring this over the rest of this term and next term as well. I won't, again, go through all of the details on this chart, but just wanted to point out the types of privacy legislation that have passed across the nation. There are a number of laws relating to genetic privacy. There are at least 2 brand new comprehensive data privacy laws, as well as a number of other topics. And this is just a representative example of the number of laws that were under, bills that were under consideration or enacted over the past year. So touching first on California, which may be a homer choice, given that that's where I live. The California Consumer Privacy Act, the CCPA, entered into force in January 1, 2020, and really was a fork in the road and changed the arc of U.S. state regulation on privacy and cybersecurity. Voters in the November 2020 election passed the California Privacy Rights Act, or CPRA, which has a staged rollout from an going into effect perspective, but by and large, the provisions of CPRA will go into effect in January 2023. Importantly, there's a limited private right of action with statutory damages after a data breach, as well as the development of a new agency, the California Privacy Protection Agency, as well as additional protections and obligations relating to sensitive personal information. There are enhanced rights, user rights to correct and to opt out. And we are seeing a lot of development from both the AG, which is charged with enforcing the existing CCPA, a transitional board, which is charged with helping set up this California Privacy Protection Agency, as well as a notable development this week of the announcement of an executive director for the CPPA, Ashkan Soltani, who is well known in the field, has served in a number of roles, including as the chief technologist at the Federal Trade Commission, and was a notable proponent of CCPA and CPRA. So we can expect to see a lot of really interesting developments out of the both board and the agency, as well as the Attorney General's office over the course of the next 15 months. And I think that we are going to see a lot of developments out of this law and out of related actions that are going to touch not just on privacy and the handling of information, but also directly on security as well. So I mentioned earlier, Virginia passed the CDPA, which goes into effect in January 1, 2023. Unlike California, CDPA does not have a private right of action. Enforcement is handled by the Virginia AG. This law is very different than CCPA in many ways. It's really patterned after GDPR. The language and nomenclature draws from GDPR, the European framework with which many of you may be familiar. I'll also put a plug in for some of the rest of our series this month, including a roundup that will touch on European and APAC developments. But CDPA cribs liberally from GDPR, but also takes the quote, do not sell concept from CCPA. Virginia is a law that we think has potentially significant implications as a roadmap for other laws around the country and other state legislatures. The enforcement mechanism, as mentioned earlier, is one that is relatively more limited than CCPA and CPRA. So we will see whether that gains traction as other legislatures consider similar provisions. Colorado, following Virginia, passed the Colorado Privacy Act, which comes into effect in July of 2023. It also does not have a private right of action, but it is unique in that it allows enforcement not just by the AG, but also by district attorneys. So we will see a certain interesting degree of localized enforcement. There is similar requirements around obtaining opt-in consent before processing sensitive data, which is a not unique given that Virginia has it as well, but a distinct construction around how that type of data may be processed. Under even GDPR, there are alternative legal bases for the collection and processing of sensitive data. So we will really have to see how this plays out in practice. There are also requirements to maintain technical and organizational security. One of the most controversial or as yet to be determined provisions of the Colorado Privacy Act is the universal opt-out mechanism, which we will have to look to forthcoming rulemaking to understand the full impact and import of. The Colorado rulemaking, I think, also will be particularly interesting, given that the Office of the Attorney General in Colorado is led by a noted tech policy veteran, Phil Weiser, who also has been was the dean of the University of Colorado's, I believe, School of Law. So we will look to them for a lot of thought leadership on this as well, even as California continues to churn out rulemaking in advance of the January 1 date for CPRA. On this chart, we are just, this is a high-level overview of some of the comparative rights under the 4 regimes that we discussed. I won't go through this in too much detail. And again, this information is easily available and is included in the client alerts and legal updates that we provided. So you can easily find this on our website and don't have to jot it down just now. But you can see that there are key distinctions, that we are really living and working in a patchwork, and that there are some key distinctions, but also similarities between these laws. You can also see that there are a number of distinct obligations on what are called data controllers, the entities kind of responsible for the collection or processing of information. And that I think over the next several years, as we migrate from CCPA towards CPRA and these other frameworks coming into effect, companies are really going to have to take a best efforts approach to comply with these frameworks, to develop forward-looking policies, procedures, as well as just thought processes as to how to handle information, given that we are working in a very fragmented legal environment. Marcus, over to you.
Thanks again. So it wasn't that long ago when we were looking at primarily one state when we talked about state regulation of cybersecurity, but there is a significant amount of activity on the state level, as you can see. 45 states combined in total introducing or considering more than 250 bills or resolutions dealing with cybersecurity in 2021. You expect to see that to continue into 2022. Next slide, please. Well, I'm not going to read all these bills, but what I do want to point out is that you saw this, we've seen Maine pass an Insurance Data Security Act, and a number of states focus their attention on election protection legislation. That is something that we expect to continue. Vivek?
Thanks, Marcus. I'm not going to spend too much time on some of these federal legislative proposals. There have been a number. Senator Gillibrand introduced the Data Protection Act of 2021. Senators Wicker and Blackburn introduced the Safe Data Act. And each of these take different approaches to what a privacy regime might look like, including on key topics at the federal level, such as preemption as well as enforcement. I think that what's important here is that nothing here has gotten past committee, and we really don't expect this Congress to enact a comprehensive privacy law. So being cognizant of that as well as time, I'm going to fly through some of the next couple slides and hand it back to Marcus. Marcus, over to you.
Okay, next slide, please. All righty. So, kind of a similar vein. There have been many bills focusing on cybersecurity, critical infrastructure, and energy and pipeline security. Next slide, please. Basically, there's no current federal law that requires federal, with certain exceptions, that requires individual companies to disclose data breaches. Certainly, there's no comprehensive law. Congress is looking at maybe passing such legislation, but right now nothing's been passed, and we only had proposals and bills. In interest of time, I'm going to move past this. Next slide, please. On August 5th of 2021, the U.S. Senators Marco Rubio and Dianne Feinstein proposed a bill to strengthen the security of critical infrastructure and target governments knowingly harboring cyber criminals. It would do a few things: require development of cybersecurity standards for critical infrastructure, require development of cryptocurrency regulations, create a state-sponsored ransomware designation, require the president to impose sanctions and penalties on states designated as sponsors of ransomware, and require federal agencies, government contractors, and critical infrastructure owners and operators to report ransomware operations within ransomware attacks within 24 hours of discovery. Next slide, and to Vivek.
Thanks, Marcus. So just briefly, there are a number of legislative proposals under consideration on cybersecurity, as Marcus mentioned. This one put forth by Senator Peters and Senator Portman relates to the designation and declaration of significant cyber incidents after a breach of public and private networks. One of the other topics that we flew through earlier, but I'll touch just very briefly back on, is an active conversation underway on Capitol Hill regarding the potential for mandatory breach notification for critical infrastructure operators to the Department of Homeland Security. There's an active discussion underway, and a number of senior administration officials have appeared before Congress to discuss both the substance and timing of such notifications if an incident impacts critical infrastructure operators in the private sector. We're watching that closely, and I think that things evolve on a day-to-day basis, but we'll certainly be issuing and updating client alerts and legal updates as things come to fruition. Being cognizant of time, I will continue to fly through some of this legislation. I think some of the good questions are why some of this legislation has not really advanced as far as it might. I think that despite there being a bipartisan consensus around the importance of privacy and cybersecurity issues, it can be difficult to come to ground on a particular legislative proposal, particularly when there's interplay with the private sector. We also see a lot of challenges just getting this on the calendar. We're not seeing a lot of time and attention paid to these issues in terms of Congress's actual time discussing and marking up bills. And I think that there are, as everyone knows, very large packages that are currently underway and consuming a lot of the oxygen in Congress. So we will have to see whether they come back to some of these issues in the months to come. Marcus, over to you.
Next slide, please.
I think we're off by just one slide, Marcus.
Okay, I see. Okay, thank you. So the DHS Industrial Controls System Capabilities Enhancement Act was introduced by U.S. Rep. John Katko and provides certain responsibilities to CISA. Next slide, please. The Defense of the United States Infrastructure Act was introduced by several senators and would establish the Bureau of Cyber Statistics as well as a National Cyber Resilience Assistance Fund. Vivek?
I know we're running short on time, but we will just run through a couple of key litigation developments we thought are worth mentioning. First is under at the state level under CCPA, as I mentioned, in California, which has a private right of action allowing California residents whose information has been subject to an unauthorized access or exfiltration, theft, or disclosure as a result of a violation of a business's duty to implement reasonable cybersecurity safeguards, can seek between $100 and $750 per incident or actual damages, as well as declaratory and injunctive relief. We've seen over 200 CCPA-related actions filed since 2020, but no federal judge or jury has awarded damages to plaintiffs under the new law, and only a small number of cases have survived the motion to dismiss. A lot of these cases involve claims that a business failed to implement reasonable security safeguards that resulted in a data breach. And a number of cases have attempted to expand the scope of the private right of action to include claims violations of consumer privacy rights. A number of cases have also included unfair competition claims within the CCPA claims, and others reference the CCPA as supporting other claims. Several key rulings in early cases suggest that courts are going to narrowly construe the private right of action And key findings, in particular in a case called Gardner versus Walmart, was that CCPA is not retroactive, that plaintiffs must sufficiently allege a compromise of personal information as defined in the CCPA, that the violation of CCPA cannot serve as a predicate for a plaintiff's unfair competition law claim, and it only confers a private right of action for violations related to personal information security breaches, not the failure to obtain consent or notice. We've also seen kind of a reaffirmation of some of the plain statutory text. That's that CCPA has an exemption for protected health information when the defendant is a HIPAA-covered entity in the DeLuna versus Tandem Diabetes case. We don't expect the trend of CCPA-related class actions to taper off, given the number of cyber attacks that we're seeing across the sectors. But privacy professionals and litigators are going to have to continue to wait and watch for additional rulings to see how these will be interpreted by the courts. And also have to wait and watch to see how important and how relevant that precedent may be in the context of CPRA, which will come to replace CCPA in 2023. Marcus, over to you.
Okay, so a few points I just want to make about privilege here. Courts have shown that, as we already knew, especially the litigators, that not all assertions of privilege are going to stand up in court. And these three cases have taught us a few things about in basically maintaining privilege in the aftermath of a cybersecurity incident. One of them, in terms of the way you engage the vendor, matters significantly. Just changing the paper for an existing vendor that was engaged for business purposes or for IT purposes beforehand will not withstand a challenge of privilege. Also, basically creating reports by these vendors for multiple purposes or primarily purposes that include business purposes or other purposes generally will possibly not withstand a challenge to privilege. And finally, if you're engaging a vendor for the purpose of conducting an investigation and creating a report, make sure that it's focused on litigation only. If it has other purposes, even if they're not the primary purpose, for sharing with business members of the company, the FBI or others, it's likely not going to withstand a challenge to privilege.
So I'm going to just mention again that for those of you that are looking for CLE credit, please include the code 10 Roundup in your attorney affirmation form, 10 Roundup. This brings us to the end of our session. I know that we have absorbed most of the time with our conversation and our background. As we said, we could really fill up several days with this content. So we hope it's been informative, and we will look to your questions that were in chat and follow up to the extent that we can. Marcus, over to you.
Thank you so much. We have been monitoring your questions in chat. We've tried to incorporate in some of our remarks, answers to your questions, but we also will be taking a look at them offline, and we will get back to you with responses. Again, we can't thank you enough for taking your time to listen to two lawyers talking about cybersecurity and privacy developments. We look forward to your joining us for even more exciting programming during the month of October. Have a great day.
Thanks, everyone.